Nick, what's your job with TressCox?
So I'm a partner at TressCox in its Melbourne office, working in the area of workplace relations.
Right.
That gives me a lot of experience and work in the contingent labour area for recruitment organisations and large users of contingent labour. I also do a lot of work on the privacy strategies from a recruitment perspective.
Okay.
For example, how recruiters deal with LinkedIn and the like.
Okay. So Nick, on this particular interview, I'd like to talk a little bit about the contingent side of things. We're seeing many organisations now are paying a lot more attention. They've got their permanent recruitment in order, and they feel that there's some issues they need to attend to. What are the types of risks that you think, if they were going to look in the contingent side of things, they should be aware of?
There is a great deal of risk that exists in engaging contingent labour, especially on a large scale, that unfortunately I don't see being fully recognised by some of the users out there. The first port of call from my perspective in properly quarantining and avoiding that risk is to have a solid set of terms and conditions with your suppliers.
Right.
The reality is that they're getting a margin from the working relationship because they should be taking on a lot of that risk. But you've got to clearly confirm that in their terms and conditions. For example, is it clear that they're the employer? Is it clear that they have all of the burdens in relation to paying the right kinds of taxation? Are they wearing the responsibilities in terms of workers' compensation, not only from an insurance point of view, but also from a training point of view? It's really useful to have all of those things really clearly set out in the standard terms and conditions.
And what about where an organisation's contracted directly with its contract workforce or contingent workforce?
The same thing still applies. You should have a solid set of terms and conditions with your contractors. Ideally, those contractors will be operating their own contracting business. There'll be a PTY Ltd, and that therefore you can apportion to them a lot of the same responsibilities that you can apportion to a large-scale contingent labour supplier in terms of taxation, workers' compensation and the like. So there's not a huge amount of distinction between how you engage both types of contractors.
And what about, where it is a contingent hire and they're a PTY Ltd, and they're working predominantly for the one employer, is that an issue?
It can be certainly over time. If an individual is engaged on a project basis for a specified period of time, there's still a good prospect that they'll genuinely be found at law to be a true contractor. However, if someone is working exclusively for the same company over an extended period of time, there's no discernible particular project that they're working on, there can be an increasing risk that the law will deem them to be an employee of the end user. And that can lump the end user with all sorts of obligations in relation to employment entitlements, taxation entitlements, work cover entitlements and the like.
Wow. So Nick, let's say that, and I'm sure this is the case, that as an employer you've discovered you've got some risks. You've been working, contingent tends to be decentralised, and you've got all sorts of arrangements that can create some liabilities. And I'm the employer, and I come to you and I say, Nick, what do I do? How do I sort of rectify this? What would you advise me?
The number one, of course, is I'd want to look at the terms and conditions. If they don't support the user as well as they could, if the work has been there for a long time, then it is important to not have a knee-jerk reaction.
Right.
For example, if you panic and decide to immediately terminate that relationship, that's when all of these risks might crystallise.
Okay.
For example, you might find yourself with an underpayment complaint. You might find that the worker has notified the ATO. What I tend to try and do, and a lot of the times, whether or not the worker is a genuine employee is a grey area. It's not certain, but there's a prospect that there might be some risk. So take a look at that relationship, maybe have a discussion with the worker over the fact that the relationship has changed over time, and maybe it might be worthwhile entering into a new form of relationship. For example, it's not unheard of that long-term contractors can then become legitimately employed by the end user. If you've had the same contractor for 5 years, they've worked on a number of projects, maybe it's time to reevaluate the relationship.
So do you help organisations with that? I mean, do you look at each individual case and advise them on that, or how does it work?
That's something, unfortunately, that regularly occurs. It's much, from my perspective, it is much more advantageous that if an employer or an organisation comes to me voluntarily and says, look, I've got this worker, nothing's happened yet, but they've been here for a while, what do you think I should do about it?
Right.
Then you can do it with some degree of comfort. The more disadvantaged time when employers come to me is that they've already had a claim.
Right.
They're already being investigated by the ATO.
Right.
Or the Fair Ombudsman is already undertaking an audit in relation to the underpayment of employment entitlements. Then it becomes much more challenged. You've got less leverage to work with, you've got less time to work with, and you don't have the opportunity to create a case around how you want to change the relationship.